Yep.
We're live.
All right. Good morning. We are in Senate Judiciary. It is March 14th. We are taking one last look at our miscellaneous judiciary bill and probably voting it out shortly. Eric, we have lead counsel with us. Eric Fitzpatrick, who's going to go through any of the changes.
Yes, thank you to the chair, and as the chair mentioned, Eric Fitzpatrick with the Office of Legislative Counsel here to talk to the committee about the most recent finalized version of the committee amendment to S-109, which is an act relating to miscellaneous judiciary procedures, the annual judiciary miscellaneous bill. I'll first just point out there's only a couple of changes between this version and the previous one, so I'll point those out first, and they're both on page 5. This had to do with, you recall the discussion about the provision being added that I think it was S. I don't remember the name of the bill, the number of the bill. That was initially S 41, perhaps. But anyway, there was the zip code, the 61. 61. That's 61. Right. So the zip guns, switchblade knives bill, and what that bill is doing is essentially repealing the crime of possessing a switchblade knife because of the fact that there is no definition of switchblade knife and inadvertently may criminalize lawful behavior. So the couple of changes here, your first one's on line 13. That's when Senator Ruth pointed out that since you're repealing the switchblade knives portion of the crime, then it shouldn't be in the title any longer. So those words are struck on line 13. The second change is on lines 20 and 21. This is the idea, remember, this is the expungement piece, so that since you're repealing the crime, asking or directing the court to go back and repeal previous convictions of that crime. This particular one offense is a little unusual in that there are essentially two offenses embedded in one statute, the zip gun piece of it and the switchblade knife piece of it. And you wouldn't want to expunge the convictions for the zip gun piece of the offense, but that's remaining a crime. You only want to expunge it for purposes of switchblade knife. So that language was added on line 21. They say direct the court to expunge criminal history records and convictions of this statute 13 VSA 4013. And the new words start there. For possessing, selling, or offering for sale a switchblade knife. So that's only those types of the convictions that are going to be expunged. And as it happens, this came up last night at Judicial Retention Committee. Just informally, I was speaking to Judge Zone and to Terry Carsones about it, and they indicated that they would be able to distinguish between those, particularly because there's not that many offenses. So, in fact, Judge Zone said that he would personally go through the records and determine which ones were which, even though they're very old. And Terry said they're going to have to order the records to get them. And so, but I offered that we could provide them with a flashlight and bottle of way out. That would be helpful for expunging the records. He seemed appreciative. As though,
I might have one in my desk drawer.
oh, there we go. Right. That may be helpful. So anyway, they thought that was feasible, and they might even have the numbers just for purposes of understanding. It's curious how many are zip guns and how many are switchblade knives. I think Judge Zone's prediction was there would be 0 zip gun convictions, and they would probably all be switchblade knives, but they don't know. But they might be able to get those numbers within the next couple of weeks, so these that'd be interesting here.
Yeah, absolutely.
So those are the only changes. I could do a quick high-level review if you wanted, or
Yeah,
maybe
we're able to just get a quick within the next 5 minutes or so that Senator Ruth can vote for this, or we can come back in half an hour.
Sure. I'm not sure how the House's time will work on it.
Yeah, right.
The resolution.
Yeah, well, yeah, yes, just take it away and we'll see where we're at in about 5 minutes.
Okay, sure. First section was the one that was recommended by the court diversion program over at the court, just clarifying some language that they use the term person referred to this program as a responsible party, and some editorial fixing of a off sentence on line 13 of page 2. Sections 2, 3, and 4 were all recommended by the judiciary, by the court. Section 2 clarifies that it's the General Assembly that determines how many superior judges they are, and by phrasing it generally in statute rather than using a specific number, That way you don't have to change the statute every time the numbers change, is the idea there. Section 3 more accurately refers to an underlying statute about possession of tobacco products, because it's not just possession, it's also procurement. Not just actually possessing them, but also, for example, purchasing them or possessing them unlawfully. Section 4 clarifies because in judicial bureau proceedings, the law enforcement officer can void the complaint. But this is just making it clear that, well, that doesn't mean they have unfettered authority to void a complaint. There's only, they can only do so, they're not prohibited from doing that by other law. Section 5, moving over on page 4, that's the minor in using a false ID to purchase tobacco products is a civil offense, not a criminal offense. So the term fine in line 4 shouldn't be used because that's a criminal term. So it's changing the terminology to be more accurate. It's subject to a civil penalty, not a criminal fine. Section 6 is the section you discussed yesterday. This is the idea that private attorneys can have the same access to court records online as contract attorneys and publicly employed attorneys can have remotely, not just, they already have that access if they go to the courthouse because they can have it remotely. Section 7, there's a correcting an inconsistency in the sense that generally speaking, attorney's fees, when attorney's fees are available, the court doesn't have to have a hearing on that if the fee is less than 2% of the judgment. And this clarifies that if the case can mortgage redeems as well as in every other.
Just interrupt you, Eric.
Yeah.
I was thinking we have gone over a lot of these a couple times previously.
Yeah.
From other witnesses. I think the only recent big change was section 25, the firearm surrender compliance working group.
Absolutely. Yeah.
If you could give us the highlight on that one more time.
Yeah, definitely. Yeah, and you're right. The others are probably 2 or 3 times I've already been used. So yeah, exactly. So that one is new. It's a product of a recommendation from the Vermont Network, and the idea is that the Office of the Attorney General convenes a firearm surrender order compliance working group, and that's the idea that there are several different places in statute where firearms may be ordered to be surrendered. That could be relief from abuse order proceedings. It could be emergency legal protection order proceedings, stalking order proceedings. They're different cases and different situations. And the idea here is to develop a uniform procedure for how that's going to work. It doesn't change anything about when firearms can be ordered to be surrendered. That it remains as it is under current law. It's just, I think, with the goal of trying to make uniform the proceedings in different areas of the law so that there's not any inconsistencies and they can all be treated the same way for efficiency purposes. So that's the idea. The AG is the one in charge of convening this working group. You see the list starts on line 10, page 18 of who's going to be in the working group. At least it's actually only AG is free to consult with anybody else who might be, they think is relevant, but it includes both law enforcement. It includes federal firearms licensees. That's over on page 19, line 11. So representatives of the different communities, the idea is there. ATF members, kind of a wide variety. And then they have to report back, that's bottom of page 19, to the Judiciary Committees and Justice Oversight by November 15th of this year with their recommendations for how they might create this kind of unified process.
Thank you.
You bet.
Committee, any questions, comments, complaints? Before we vote?
I assume you want me to keep my complaints relative to the bill.
Yes. If you don't like. Well, in that case, I would entertain a motion to vote this out favorably.
So moved.
Great. That happens.
Yeah.
Any further discussion? Great.
Senator Norris,
Yes.
Senator Bielowski.
Yes.
Senator Brew,
Yes.
Senator Meadows, yes. Senator Frasheen.
Yeah.
5-0-0.
Thank you, Eric,
You bet.
for all your help on this.
Yeah, definitely. It's
It'll
always
be
an
the
interesting bill.
smallest miscellaneous bill I've ever seen.
For the moment.
For the, yeah.
Fair point.
Well,
We send them, what, a 5-page bill and get back 25 pages?
And then we have fun.
Probably.
That's the typical way that it works. Yeah.
Well, I think we've done all the things that we need to do. A lot of bills out.
Yes, yeah,
Probably, I think by my. Next time I'll be on the floor though.
It won't be on the floor till next Wednesday, probably.
Yeah,
Right?
that's, if it doesn't, yeah, is there any money involved in this at all? And,
There would be the working group in there.
yeah.
The working group, isn't there? Or no?
Oh my God.
No, we left that one.
Well, that's.
Yeah, we didn't.
I think they're all state employees, well,
The FFL.
yeah, the FFL, that's right. So it may be, I'm not sure how that
Might
exactly works.
take a quick pass through and for
Right.
folks, but yeah, aside from that, so yeah, probably end of next week. Once it.
Can I do it right now? It's fresh in my head.
Yeah.
Pull it up, pull it up. Pending entry into the notice calendar.
Yeah. Here's what I want for my presentation.
Yeah, I can do it right now.
Thanks. We can